Hello, my name's Alex Greenwood. I'm a barrister and a door tenant with Gough Square in London. Many of you, I hope, will know me and maybe heard me give talks before, but I like to think I specialise in regulatory work, trading standards work of all sorts. I'm going to talk today as part of the virtual symposium from here in sunny Wales, where outside I can hear the relentless pattering of rain on the roof of my study, about trials in a pandemic. Goodness me, how timely. When I first suggested this talk back in the summer, of course, there was the green shoots of recovery. We were being encouraged by the government to go out with free meal deals, get back to work, go back to the towns and cities. It was all going away. Goodness, how long ago that seems. And so the talk that I suggested back then didn't seem very timely. In fact, it seemed as though it was fairly pointless, or potentially pointless. But that was fortunately for me, unfortunately for all of us. It looks as though the COVID restrictions are here to stay. It looks as though the restrictions will continue to apply in the court environment for many, many months and perhaps years to come. Of course, we must have a functioning justice system. At the moment, it might be thought it is not functioning. The current backlog of cases, Crown Court cases, runs into the tens of thousands. And if you were to lay informations today, get a pre-trial preparation hearing in perhaps a month or 6 weeks' time, it would probably be towards the end of next year at the earliest that you could expect a trial. That is the extent of the problem. Crown courts in England and Wales are only able, in the main, to run 1 or 2 trials in any given court centre. 1 or 2 trials involving 1 or perhaps at most 2 defendants. Most courts are simply not geared up for social distancing and the problems that gives rise to. So the backlog will continue and the delays will go on. But what has been done and what steps have been taken to ensure your safety and the safety of witnesses? One of the big problems, of course, is encouraging people to actually come to court. Well, the use of the common video platform is now routinely adopted in cases. What that means is rather than having to drive for hour after hour for perhaps a 5-minute mention, most routine, mundane court hearings and indeed plea hearings, perhaps some sentencing hearings, take place now on the video link from the advocate's home beaming into court, where primarily the defendant is on bail. When they're in custody, then ordinarily, certainly the defence representatives should still be going to court. So the justice system is slowly gearing up. I was fortunate or unfortunate enough to be involved in the first Crown Court trial back in May of this year, post-COVID. And what this talk is aimed at is to perhaps allay fears, perhaps give you an idea as trading standards officers there to support the advocate, giving evidence yourself, there to ensure that witnesses are put at ease, but to tell you as much as possible about the measures that should apply equally in the Magistrates' Court as the Crown Court. So where to begin? Well, back in April, it was first mooted that we would have to get the justice system up and running. How did they go about that? With the help and the work of Public Health England and in Wales, Public Health Wales. Visits to the Crown Court and lengthy and detailed consultation with the court staff, with the barristers, solicitors, to try and formulate a way that trials could take place. Measures were introduced, guidelines set out, and documents produced by Public Health England setting out the steps that jurors, witnesses, advocates, and goodness, even trading standards officers could expect to protect themselves. We're going to look at those today. I'm going to discuss how they've been practically implemented and perhaps updated since back in May when first introduced. So I trust that you'll pardon the screenshot, but this is from Public Health England's own website. This is what the government body set up to protect the health of the nation demands within the court environment. And it starts like this. Jury trials are one of the cornerstone of our justice system. In whatever capacity you are coming to court to take part in a jury trial, your safety is our priority. Where does it start? You can expect us to lay out the courtroom so there is enough space for social distancing. One of the first things you will notice is the days of members of the public piling into the courtroom are long gone. In most instances where members of the public want to watch the case, they have to do so from an entirely different courtroom, with the proceedings being beamed via the court video system into that separate room. Because of course, justice is a public thing. It must be seen to be done, and it would be inconceivable to do it behind closed doors. Everybody has to have a clear line of sight to the other people in the hearing. In the jury trial, every juror within the courtroom, maintaining social distance, has to be able to see the witness giving evidence. In Scotland, they've adopted a different system. Witnesses give evidence, defendants give evidence, sometimes from entirely different venues, courtrooms, or even their own homes. And as time has passed, that's been adopted in our system. I have a trading standards case next week where the majority of our witnesses will be giving evidence from their own home. And in that case, it's done either via their own computer terminal link, or we have had to put in links for them and ensure, of course, that they have all the necessary documents before them to be cross-examined upon. So basic measures brought in to assist, but measures many of us think should have been brought in years ago in any event. As always in a crisis, the speed of change has accelerated, and steps that perhaps would have come in 5, 10, 15 years have been brought in, and hopefully will never go away. It has always been a mystery to me why we have to have witnesses brought from the other side of the country to give evidence in light of the facilities we now have for video link. So, more than one courtroom used, because of course the court is a generic concept. The fact that the court sits in a courtroom does not limit the court to that courtroom. And in the trial that I dealt with, and I've done a number of trials since May, that is commonplace. It is commonplace to have members of the public instructing solicitors, perhaps you as trading standards officers there, observing proceedings if you are not witnesses yourself, or after you've given evidence, being in another courtroom, watching the witnesses over the video link, messaging by email rather than tapping counsel on the shoulder or nudging them in the ribs or sticking a note under their nose pointing out how the barrister's getting it completely wrong. Social distancing in all the rooms that individuals use. Making sure there's enough space to keep a safe distance in waiting areas. You may have observed those of you who've been to court, seats taped off so that individuals can't sit next to each other. Only deliberation rooms where there is room to maintain social distancing, to be used for conferences. Limitation on the number of people who can go into the conference room. The days of the defendant, his girlfriend, his father, his mother, and the dog going in are long gone. Consultation in private rooms, of course, has to take place, but I've heard some horror stories in the magistrates' court where no consultation rooms exist and lawyers are expected simply to discuss the case in the corridor. Well, that isn't acceptable, and perhaps objection should be taken, but that is perhaps on one level a consequence of the rules and regulations. Video link rooms. The witness giving evidence as they would if they had special measures, but not just from the courtroom, from other courts, and as we've already discussed, from their own home, where possible. And of course, under the increased restrictions that we now, in many instances, have to act under, where regional variations mean witnesses are not, in theory, allowed to leave the area. Of course, coming to court is an exception and is a reasonable excuse. But nevertheless, of course, we should all be working to ensure that as little travel takes place as possible. Rooms for advocates. The robing room, that hotbed of gossip. Well, they're still used, but there is social distancing within there. Chairs will be taped up or have a sign on them to stop witnesses, defendants from sitting next to one another too closely. And these things are rigorously maintained. There is no difference, of course, between the obligations on a Tesco supermarket, where the supermarket will be obliged to have members of staff wandering around, enforcing social distancing, and the court estate, where the court ushers adopt that role. Entering and leaving the courtroom is far more regimented, directed by members of staff, again ensuring that 2-metre distancing is maintained. In jury trials, the jurors have to be staggered when they are allowed into the courtroom. The object of the exercise is to minimise movement and minimise, therefore, the possibility of random interaction, bumping into each other, if you like, that might take place. Social distancing always in the forefront. And it's not simply the court staff. I myself was told off, again, by the judge in a trial for having the temerity to approach my opponent, to talk to them quietly about a matter that we didn't want the jury to hear. I was upbraided, told off, and we had to do it via email. So make sure that you maintain social distancing. Masks will now have to be worn within the court estate, on the court building, other than perhaps in the courtroom itself, subject, of course, to your own discretion, giving evidence, barristers themselves. In the trials that I've seen, the advocates tended not to wear masks within the actual courtroom, and neither back in the day, back in May, when it wasn't compulsory, did any of the jury take up that option. So what else can we expect? Well, the courts look different. There are clear floor markings and directional signs. One-way systems have been adopted where there are 2 entries into the court. One is now the way in, the other is the way out. It's exactly like going to the bigger supermarkets. Security staff give clearer directions, limit the number of people allowed into the court building, much like going to the supermarket, limit the number of people going into the courtroom to watch proceedings. Refreshments are no longer available. Canteens have been closed. Water is no longer provided, even for advocates, other than a water bottle given to members of the jury, the magistrates perhaps, the judges, at the outset, which they are expected to use throughout. Where video presentations are given, evidence via the ClickShare system, TV remote controls, keypads, trial bundles must all be wiped clean. And that's an important point for you as CTSI officers. The days of turning up at court and trying to put things together when you're there, well, you can appreciate you even touching items, witness statements, evidence, in theory, could transmit the virus. And so most jury bundles are prepared well in advance, copied on a sterile machine. The representatives of the Crown Prosecution Service, where it's a normal trial, or you as the Trading Standards Officer, expected to be wearing gloves and a mask and ensuring that sterile documents are provided. In a jury trial, every juror has to have their own bundle of exhibits, indictment, and any document that the witnesses wish to put before the parties wish to put before the witness. The oath is taken on the Holy Book, but it will be often present either in a plastic covering or having been freshly cleaned with a sanitized wipe. Hand sanitizer will be available and is available throughout the courtroom, and parties are expected to use it. During the course of the trial itself, the trial will stop from time to time to allow cleaners to enter the courtroom and to clean all surfaces. So you're obliged to follow the signage, to follow the direction signs, to bring your own refreshment, avoid touching anything you don't need to. The witness themselves can bring their own holy book if they wish, frequent hand washing, and all of those steps that seemed so alien all those months ago, but now seem normal and part of everyday life. Witnesses, where a witness does in fact go to court, they are of course to be kept in a witness room, socially distanced, and so the need for a batting order setting out the witnesses when they should attend is far, far more important than in the past. And the need for them to be in court no longer than they absolutely need to be. Witness statements should be given to them, of course, having been printed off in a sterile fashion and taken into court by the witness, so there can be no question of them being handed a document mid-evidence which might have been touched and is potentially contaminated. So there she is, Lady Justice McGowan, a High Court judge conducting the first Crown Court trial post-COVID. Goodness, it was an experience. She'd been down to Cardiff, where the trial took place beforehand, checking the measures, seeing the mechanics of how the trial should take place. Likewise with the advocates, we attended the week before on a number of occasions to see the new measures to make the trial as safe as possible. And it was stressful. The possibility of a juror coughing was always in the forefront of our minds. In fact, it had happened to me. In the last jury trial I did before March, one of the jurors had coughed during the oath, just as things were hotting up. You can imagine how that went down. By the following day, that juror had self-isolated and a Crown Court trial was abandoned. The jury were discharged because in the view of the judge, they would be more concerned about whether they'd contracted COVID than being able to concentrate on the evidence. It's that serious. And the reality is, where we run these trials, particularly bigger trials we are running them on a knife edge. All it takes is more than 2 jurors to drop out of the equation, and the trial may be jeopardised. So Lady Justice McGowan, how did she approach her task? Well, there was a judicial homily, as they are called. At the beginning of the trial, she read this out to the jurors. This is a normal trial being heard in unusual circumstances. It's important. The trial is fair. It's my responsibility to ensure that happens. One important aspect is that you can consider the evidence without worrying unnecessarily about anything else. In our trial, the first trial, as with all jury trials, rigorous questionnaires asking robust questions were handed out well in advance. We had what I describe as ninja jurors, the elite, those, bearing in mind everyone was still in lockdown and had been for several months, who were desperate to get out and carry out their public duty. The judge continued. A great deal of work has been done to ensure that you can participate in this trial safely. Well, I hope you appreciate that point. It's important that you know that all the measures in place to achieve that have been tried and tested by Public Health Wales. That's why you'll sit in different places around the courtroom and around the building. One of the most obvious and notable features is that the jury no longer sit in the jury box. The courtroom, depending upon the court layout, but most courtrooms now have the advocates in the normal place. Perhaps if there is room, the solicitor in the room as well, although my experience is the solicitors are often with the general public in a different court room, observing proceedings via the link. But the jurors are spread, some to the right, some to the left, in numbered seats, 1 to 12, all socially distanced, marched in order to take their seats, maintaining social distance, and then marched out again. You would think that that meant the trial was much longer. And perhaps in that regard, in that initial stage, it was. But the strangest thing was for the advocate. Suddenly, you're no longer addressing a bench of 12, but like a Roman in the Forum, you are addressing a crowd of jurors all around, watching you from every angle. And so the speech had to be given in panorama, as it were. So the jurors sit in different places. Arrangements, as the judge went on, had been made to ensure a safe distance at all times, that they were told about all other measures put in place for their safety and to protect their health and, of course, to reassure them. As she went on, as you will know, steps are being taken to return slowly and carefully to normal life. Well, this was back in May. Goodness me, how long has it been? One of the important parts of life that has been put on hold is jury trials. And as she said, this is the first trial in Wales, and it was in England. So you will play an important and essential part of that process. You have been asked if you can serve as a juror in this fairly short trial, estimate of however many days it was. If you feel, having seen the arrangements, that you will be too distracted by concerns about public health to concentrate, then please tell a member of the court staff as soon as you go back downstairs. The idea was to eliminate those of perhaps a nervous disposition who would in due course feel unable to continue. Now a question about the trial itself. We will hear a list of names and places read to us in a minute. Blah, blah, blah. The usual homily. But you'll appreciate from that the court seeking to search out for any problems, to reassure the jury and see if there were those who might not feel able to carry on at an early stage in order that they could be replaced and, if possible, the trial completed. So what were the steps that were undertaken? Well, we've gone through, of course, Public Health England's formal document. There had been inspection of the court facilities and procedures, and they were endorsed by Public Health Wales. I took part in a hearing down in Truro, where a solicitor had refused to attend. The solicitor's client, the defendant, had refused to attend, citing COVID as a reasonable excuse. The judge in that court indicated it was not a reasonable excuse. He required their attendance and threatened a warrant arresting them if they did not attend. So, Public Health Wales endorsement was crucial to his consideration. He actually referred to it in his observations. They have rubber stamped these measures. The courts are as safe as they can be. Fear of the coronavirus is not a reasonable excuse for non-attendance. What other steps? Familiarization in advance. You may want witnesses to go to the courtroom in advance, familiarize themselves, reassure themselves. Where witnesses are concerned, offer them special measures. The video link from home being the most obvious one, as I say, which practically every witness in a case I'm involved in next week will be utilising and adopting. One-way system in corridors, socially distanced in the lobby areas, separate courtrooms for you perhaps, for the solicitors, for members of the public. Courtrooms measured, 2 metre zones established for all participants. Questionnaires to identify problems. The judicial homily we just looked at. Stepped introduction of jurors to ensure social distancing. Split jury around the courtroom. Jurors in waiting brought into court in 2 groups. At the start of a Crown Court trial, of course, a jury panel is used to select the 12 who will sit on that trial. The way that was overcome was that half the panel came in at the start and were given the judicial opening that you heard. They were all led out one by one, socially distanced. The other half were then brought out. The jury were balloted when they were in the waiting room, a large area big enough for social distancing. And that's the principal problem. The problem isn't actually, in many instances, the courtroom. One courtroom, in theory, could, or 2 courtrooms can accommodate one trial. In a Crown Court centre, such as Guildford, perhaps, that might mean multiple trials could take place. But the problem is with the jurors and where to put them. Because ordinarily, of course, they'd all be in the same room milling around until they were taken into their separate jury rooms. Those spaces do not exist, and that is why so few Crown Court trials are currently taking place. The real issue is what to do with the jury when the trial isn't actually sitting. So, in our trial and in every trial I've been in since, the jury is selected in their absence and then called one by one in order into the room, numbers they retain throughout the course of the trial, much as they would ordinarily when they come in and sit at their places in the jury box. Witnesses brought in and out whilst ensuring social distancing. In the courtroom we were sitting in, it meant the judge herself had to wait to come into court as the witness used the judge's entrance, which was the only way it could be operated to avoid the witness coming into close contact with the juror who sat next to the main door of the court. Indictments, exhibits, photographs, interview transcripts, all the usual paraphernalia of the trial, all had to be provided in advance, in a single bundle, one for each juror. You'll be familiar usually with one between 2. Magistrates' court, one for each magistrate and the witness. But everything had to be thought through well in advance. the days of the defence advocate suddenly whipping a document out from behind his back and much like Pooh declaring "aha" and handing the witness the document which proved that they lied are gone. Defence advocates, as with the prosecution, had to provide the documents sterile in advance for each juror, provided before the juror came into court. Because, of course, the main problem is that the court ushers were limited in their ability. They had to maintain social distancing. They couldn't take jury notes, for example, because that would have involved approaching the juror within 2 meters. They cannot hand out documents, witness statements, exhibits. And so everything had to be thought in advance, where ClickShare, that facility to play video recordings or show evidence on the big screen, could be used. The obligation was to use it. Thought in advance as to how the trial would have to be presented. The sterility of those items, you can see there, the requirement that anything was handled with sterile gloves and placed in the folders in the absence of the jury. The empanelment, well, we discussed that, balloted when they weren't in the room, brought in 2 groups, the taking of the oath, the holy book having to be cleaned, sterilised, or in a wipeable cover, which was capable of being cleaned and sterilised between each juror giving their oath. And that applies, of course, in the magistrates' court with witnesses as well. Face masks, the option back in May, and it was an option back in May, was there. Now, perhaps a mandatory requirement except for the advocates and the witness in order that all can hear what they say. Hand sanitizers, wipes available, speeches, opening and closing speeches made like Julius Caesar in the Forum. Each juror was given a wipeable clipboard to make notes upon. The clipboards or the bundles already being prepared in advance and available, one for each, all sanitized. Once the court was assembled, of course, what to do? That cheeky chat with the defendant who wants to speak to his brief was a difficult thing to achieve. And the judges will encourage far longer sitting sessions. Once you're in, you're in. There's no nipping off to use the facilities, because most courtrooms will have jurors sitting in close proximity to the access and egress from the courtroom, such that if a defendant, for example, needed to use the facilities, all would have to leave and all would have to come back. Goodness me, that vital trip to the toilet before the beginning of the hearing never became more vital. So the sitting times were longer. How did it work? Well, it did. It actually worked quite well. In fact, although it took longer to get everybody in, although it took longer to get everybody out, the fact that everybody was prepared, had thought through things in advance, knew that they were, once they were in, they were stuck, meant it all went very smoothly. In that first trial back in May, it wasn't a trading standards trial, I confess, mea culpa. But in that first trial, it was due to last 3 days prior to COVID, when the original trial estimate was given, and 3 days it did last. And so there are time savings. Things can be run more smoothly. It didn't mean, as we all feared at one stage, that the trial process dragged on and on and on. The use of ClickShare, gloves used by court staff, the cleaning every 75 minutes or so, whenever there was a break, the cleaners scurried in and cleaned all the surfaces. And it is, of course, as much about being seen to undertake these tasks as actually doing them. Many of the surfaces were untouched, but were still being cleaned. So the maximum effort undertaken to reassure the jury, the witness, and the court staff. What about the defendant? What did he think about all of this? Well, in that first trial, his views were canvassed in detail. Was he happy having his trial? Well, he was, because the alternative was he'd been in custody for another 6 months. Those days are gone. The measures we've now discussed are adopted as routine. It is almost inconceivable that a defendant who objected to having a trial because of COVID measures would be listened to and the trial adjourned. The witnesses came in and they gave their evidence. They brought their witness statements with them. The materials that they needed to see had been prepared in advance, sanitized, placed in the witness box for them to be referred to, or of course they could be referred to documents on ClickShare. The defendant in custody. Well, there's a problem. When we first started trials, members of the security staff weren't even wearing face masks. Goodness knows how Reliance and other organisations got away with that. But for the defence advocate going down into the cells, and I know they will all be in the forefront of your mind and their safety and well-being are your principal concerns. But the staff and the cells had to accommodate them, and ordinarily what that would mean is the use of the conference room with the perspex barrier between the defendant and the solicitor. Where barristers and solicitors couldn't fit into the same courtroom, or you, as the officer in the case, perhaps having given evidence, wanting to view proceedings and participate and assist your advocate. If you weren't in the room, then the link would be available via the court email system to allow communication between counsel and solicitors. One of the big problems we faced was jury notes. You'll be familiar, of course, with notes from the Miss Marple on the jury, that lady who knows that all the advocates are useless, the investigator doesn't know what he's doing, and only she or he, Poirot or Marple, know the right questions to ask. And so in days gone by, a succession of notes came via the juror to the judge. What about this? What about that? Well, it was a problem, and we had to consider it at length, and we gave thought to how to deal with it. At one stage, the idea was even canvassed that jurors were allowed to bring into court their own mobile phones and perhaps text messages to the judge as to their questions. Well, that was soon regarded as or soon disregarded as an option. And so instead, jurors were encouraged to wait where they had a note. If it was absolutely urgent, of course, they could provide it, but it would mean everybody leaving the courtroom, the note being considered, and everybody brought back in. Well, it was a perfect antidote to Miss Marple. The Marples on the jury, the Poirots on the jury, kept stum until a break, and then the notes would come. They were far fewer and far more sensible, if I may say, than some of the notes that I've read from jurors, and they were dealt with then at appropriate breaks. During those breaks, the cleaners came in, the rooms were cleaned, the wipes were available, and water was consumed. And so there it is. We ran a trial. It was May. The jury went out. The jury came back. The defendant was convicted, and justice was not only done, but seen to be done. We were under scrutiny. The press were watching, the BBC were present and reporting. The Lord Chancellor himself was watching carefully from London to see whether jury trials could be effective. We had a coughing juror. She spluttered and coughed, but did not have COVID. And because of the social distances, the jury continued and deliberated, and the trial was a success. Many of those measures of course, are now commonplace in our daily lives. They seemed less commonplace then. The trial that I was telling you about was a Crown Court trial, but the measures have just as much relevance in the Magistrates' Court, where perhaps the informal nature of the proceedings mean that you as officers should be more insistent and more forceful in ensuring that your witnesses, lay witnesses, can be reassured that they will be safe when coming to court. But my advice is this: where possible, apply to the court so that evidence can be given via the link. If you have to attend court, be assured it is genuinely, or has the feeling of, one of the safest environments you can imagine. Far more so, in fact, than the supermarket. We've all been to the larger stores where inevitably, no matter how well enforced the one-way system is, there will always be the errant shopper who just has to pop back for something, turns around and walks around the corner straight into you. One of the benefits of the court system and a trial is that it takes place in a very formal environment. And in a way, that was a good thing, because the normal measures that we have to control witnesses, the courtroom, the structure in which the judge maintains order, lend themselves very effectively to the new additional measures. As I say, I got my telling off. So be reassured, the justice system is working, witnesses are safe, you as officers are safe. The use of the common video platform means that you shouldn't have to go for the routine, mundane hearings, and in fact, it works very much to your advantage. Those of us who drive endlessly around the M25 going to the courts throughout the southeast of England see it as an absolute blessing that we no longer have to spend hours and hours waiting in traffic jams for that 5-minute hearing. It can be done from the comforts of our own home, watched by you as the supporting officer. You're just as welcome to access the system, no doubt, and observe and learn, and that's to your benefit, to hear the directions the court gives. So please do make use of it. Do participate and observe the pre-trial hearings that take place in the Crown Court. Certainly it's routine, perhaps less so in the Magistrates' Court, but a vital step which makes all our lives much easier. If any of you have any worries or concerns, please, my email I put up at the start, it's alex.greenwood at Gough Square Chambers. You'll find it online, or please feel free, Google me, telephone me. I'm sure my details are available, but good luck. We will get through this. The justice system is working just. Trials are taking place. And as I say, justice is not only being done, but seen to be done. Thank you very much. I'm off to enjoy the rain here in Wales. So Hwyl fawr, and I hope to see you all in the flesh soon.